Well, good afternoon, ladies and gentlemen. I'm Robert George, Director of the James Madison Program in American Ideals and Institutions here at Princeton, and it's my pleasure to welcome you to this Alpheus T. Mason lecture on constitutional law and political thought by Professor Phillip Muñoz. This lecture on the founders is brought to you courtesy of John Hansel, class of 1946. Mr. Hansel initiated the Founders Lectures in 2001, during the first year of the Madison program's existence, as a tribute to his politics professor and constitutional law professor at Princeton, the late Alpheus T. Mason, from whom, as Mr. Hansel says, he learned to respect the wisdom and foresight of the men who wrote our Constitution. Phillip Muñoz is the Tocqueville Associate Professor of Political Science and Concurrent Associate Professor of Law at the University of Notre Dame. He's the founding director of Notre Dame's Center for Citizenship and Constitutional Government, which I like to believe, he can confirm or deny, was modeled on the Madison program after Professor Muñoz spent a year with us as a visiting fellow. He's also faculty director of Notre Dame's undergraduate minor in constitutional studies. Dr. Muñoz writes and teaches across the fields of constitutional law, American politics, and political philosophy, with a special focus on religious liberty and the American founding. He received a National Endowment for the Humanities Fellowship to support his book, which was recently published by the University of Chicago Press, on the right of religious liberty and the original meaning of the First Amendment's religion provisions. His writings have appeared in the American Political Science Review, the Harvard Journal of Law and Public Policy, the Notre Dame Law Review, American Political Thought, and the University of Pennsylvania's Journal of Constitutional Law. His earlier book, God and the Founders, subtitled Madison, Washington, and Jefferson, won the Hubert Morkin Award from the American Political Science Association for the best publication on religion and politics in 2009-2010. His First Amendment case law reader, Religious Liberty in the American Supreme Court, the Essential Cases and Documents, is used at law schools and in political science departments around the country. Dr. Muñoz's scholarship has been cited numerous times in church-state cases by the Supreme Court of the United States and by lower courts, most recently in the Supreme Court in the important cases of Fulton against the City of Philadelphia in 2021 and Espinoza against Montana in 2020. An award-winning teacher and popular lecturer, Dr. Muñoz has spoken at over 75 colleges and universities in the past several years. He was an undergraduate at Claremont McKenna, earned his MA degree at Boston College, and then his PhD at the Claremont Graduate School. Today's lecture is supported by the Bouton Law Lecture Fund in the Department of Politics here at Princeton, and it's entitled How Justice Alito 72, the Supreme Court's Originalists, and almost all conservatives, except Robert George, Gerard Bradley, and Philip Hamburger, misinterpret the free exercise of religion. Please join me in welcoming Phillip Muñoz.
Well, thank you very much. Can you hear me okay? Okay, thank you. Thank you, Robbie, and Brad, Shiloh, and the whole staff at the Madison program. It's always great to be here. As Robbie alluded to, I spent a year here and have been back several times, and it's, Princeton is a very special place to me, so I'm thrilled to be back. So it's a little bit painful to me to start on a critical note, but I have a complaint to register. When I was last here at Princeton, I was invited to give 3 lectures over 3 days, so I just assumed that's how it worked with me now. So I just want you to know I had 3 lectures prepared. And I just want to let you know, I'm a bipartisan and trans-historical critic of Princeton alumni. No, kidding aside, it really, I can't tell you how special of an opportunity this is for me because Princeton has been, I presume will be, the place for serious thinking about the American Constitution, starting with James Madison. So for someone like me who writes on Madison and American constitutionalism, this is the mecca of constitutional studies. So it's an honor for me. Okay. So the topic of my lecture today is the Constitution's protection of the free exercise of religion. When I was here in 2020, I mean days before the pandemic, I lectured here on a Monday, Tuesday, Wednesday, had lunch with Dr. George on Thursday, and flew home. Friday, the world shut down because of COVID. So it was great timing for me. I got all sorts of feedback on my manuscript, and then was at home for the next 9 months to finish it. When I was here to give the test lectures, I presented the outline of the book that I was then completing on the First Amendment. Now, some things have happened since then. I got the book published, and Justice Alito wrote a very long concurring opinion in Fulton versus City of Philadelphia. As Professor George mentioned, Justice Alito cited me in that opinion multiple times. In fact, there's a whole section of the opinion devoted to a chapter that I had published previous to the book, but that appears in the book. Of course, the Notre Dame Law School loved this, that one of their faculty members was cited by the Supreme Court, and when it happened, I got a nice note from the dean, and they put it up on the website. Professor Muñoz cited by the Supreme Court, and some of my friends, I told them look at the website, and they looked at it and they laughed, and because Justice Alito singled out my scholarship for criticism. There's a whole section devoted to why Professor Muñoz is wrong. Don't tell my dean at the law school. So I suppose part of what I'm going to do today is give my response. This is a new lecture. I haven't given this lecture, and as the title suggests, I don't think Justice Alito is right. Now, I really gave most of my legal response to him before in the test lectures, which you certainly can watch. So I'm going to give an overview of how Justice Alito and I disagree, but then I want to introduce a new argument that I think I think it's decisive. We'll see what you think. But it's not an argument I presented before. This is the first time I've given this lecture. So let me start with So here is the essence of my argument, that the First Amendment cannot provide a right to constitutional exemptions from generally applicable laws, at least from a Madisonian perspective, because exemptions would contradict Madison's political science of constitutionalism and of religious liberty. I suppose the broader idea I want to convey today is that we, or at least originalists, misconceive how the Constitution was designed to protect religious liberty. We focus today too much on courts and legal arguments and not enough on the Constitution's political science. So I'm going to try to show that Madison, of course the father of the Constitution, thought religious liberty would primarily be protected through well-constructed democratic political institutions, and that for those institutions to function properly, certain rule of law requirements were necessary. And I'm going to try to show that those rule of law requirements are antithetical to exemptions. Okay, so this is meant to summarize what I did in 3 days last time I was here, and this is my a brief comparison between me and Justice Alito. Let me see if I can explain this very briefly. Okay. Let's see where to begin. Let me use a case. Wisconsin v. Yoder. This is a case from 1972. Some of you probably know it for sure. The state of Wisconsin had a mandatory school attendance law. There's no homeschooling provision. So in Wisconsin, you had to go to school. You could send your children to a private school or a public school, but you just had to send you had to enroll a child in a school. The law was you had to do this until your children reached the age of 16. Number of Amish in Wisconsin, they withdraw their school-age children from schools after the 8th grade, so about 13. So a superintendent of public school started fining Amish parents every day their children were not in school. The Amish parents sued, saying, we withdraw our school children from the schools for religious reasons. The First Amendment protects the free exercise of religion. This is an exercise of religion. So the First Amendment gives us a right to withdraw our schools, gives us a right to an exemption from this generally applicable law. Everyone follow the case? Okay. the court ruled in favor of the Amish, and they did so using what Justice Alito's view or vision of the Free Exercise Clause. What Justice Alito would say is that the Free Exercise Clause protects against direct and indirect burdens of religion. By direct burden, I mean, let's say the state of Wisconsin drafted a law saying, Amish, you must send your children to school. It directly targeted the Amish. Or you may not if you go to a Catholic mass. That would be a direct burden. An indirect burden is a generally applicable law, school attendance, that doesn't take religious exercises or religion into account at all, but has the effect of burdening a religious group. Everyone understand the difference between direct and indirect burden? Okay, the court in the Yoder decision and Justice Alito would say that the Free Exercise Clause is meant to protect against direct and indirect burdens. So the Amish get an exemption. Now, they don't. All religious groups don't always get an exemption. It's a presumptive exemption. That is, the court will use a test called strict scrutiny. If the state is pursuing a compelling state interest using the least restrictive means, then the religious group does not get an exemption. So we're not going to let the Aztecs sacrifice their children. They're not going to get an exemption. But the Amish are going to get an exemption using the strict scrutiny approach. Okay? So that's one approach. That's Alito's approach, and that's how Alito thinks the Free Exercise Clause should be interpreted, and Justice Thomas and Justice Gorsuch have signed on to him. I think it's very likely, hard to know, but it's very likely that sooner rather than later, a majority of 5 justices will adopt this approach for the Free Exercise Clause. Okay. In my book, in my scholarship, I offer an alternative account. This has not made conservatives very happy because I do so on originalist grounds, and most conservatives think the Constitution should be interpreted according to its original meaning. My argument, and I'm not going to go over the whole thing, is that the Free Exercise Clause is only meant to prohibit direct burdens, that the provision was meant to be categorical, that you can't target the Amish or any particular religious exercise, but a generally applicable law that doesn't target religious exercise is not prohibited by the First Amendment. Okay. I can come back to this slide later. There's much more I could say about this. Indeed, I wrote a whole book on it. But I presented this argument last time I was here at Princeton. Okay. Let me give you what I think is one of the better arguments for my side. This is how Justice Alito and I rewrite the First Amendment. Right? I interpret the Free Exercise Clause as directly targeting religious exercises. He would say the legislature can't pass laws and the executive can't enforce laws that burden religious exercises except when there are good reasons for the state to do so. And my textual argument is the First Amendment says Congress shall make no law, not Congress shall make no law unless there's a good reason to make such a law. I don't think you can square exemptions with the actual text of the First Amendment. Most everyone disagrees with me on this. Let me just say that, But this is not all of my arguments. This is what I think my best argument is. Let me give you what I think Alito's best argument is. I didn't make a slide of this because I don't want you to remember it. His best argument, and the best argument against me, goes something like this. Michael McConnell just made this argument in a seminar we did for the Federalist Society a few weeks ago. It goes like this. You, Professor Muñoz, are effectively negating the Free Exercise Clause. Under your construction, the First Amendment protects only against a type of legislation, targeting the Amish, that almost never is passed. Moreover, from the perspective of the religious believer, it does not matter if the burden is direct or indirect. It makes little difference to the Amish whether the mandatory school attendance laws target them or only indirectly burden them. From their perspective, a burden is a burden. All that matters to them, that is the Amish, is that they are fined for doing what their religion demands. How can they enjoy the free exercise of religion if the state can effectively make the practice of their religion illegal? Your interpretation, the critics say, can't possibly be correct given the results it produces. Okay, I think this is a powerful critique. It's especially powerful when a Supreme Court justice makes it. But I think it's wrong. And I'm going to give you a different argument today as to why it's wrong. The insight I had for this argument actually came when I was in the doctor's office. This will be obvious to you in the audience. It's only becoming obvious to me. I'm not very young anymore. When I was here at Princeton, I was young. When I was here at Princeton, I played basketball 3 days a week over in Dillon Gym. And then it was 2 days a week. And then it was 1 day a week. And then it was 1 day every other week. And so I go to the orthopedic surgeon, and I'm like, I want to play basketball. And he gives me this thorough examination, and he comes back and says, there's nothing I can do for you. And I'm like, you're a doctor. You're supposed to make me better. And he said, look, you're getting old. This is what happens when you get old. You can't play. Literally, he said to me, go play golf. This is not an appealing answer. As a matter of fact, I don't play basketball anymore, and I do play golf. But when I was talking to the surgeon, I had an insight about Justice Alito, which probably has never happened to anyone before. My orthopedic surgeon fixes knees through surgery. And if you can't perform surgery, medicine is useless in his view. He has, he has a hammer, and he fixes everything with a hammer. The lawyers and judges think in a similar manner, except their operating room is the courtroom. They tend to think if rights are not protected by the courts through constitutional litigation, then rights aren't protected. This is essentially Justice Alito's argument. If the court can't protect religious believers through the First Amendment, through First Amendment exemptions, the Constitution does not protect religious liberty. But that's not how James Madison thought about rights or how he envisioned the Constitution to protect rights. And it's certainly not how he believed religious liberty to be protected. I think lawyers don't understand this because they don't understand Madison's constitutional political science. So that's what I want to try to present to you in the rest of my time today, how Madison thought religious freedom would be protected primarily through the multiplicity of interests that was made possible through the extended republic. I mean, this, as I presume you all know, is the argument of Federalist 10. What I don't think has been seen before, and what I want to try to demonstrate, is the relevance of Federalist 10 for free exercise clause jurisprudence and the question of constitutional exemptions. And so here's my primary argument in a nutshell. Madison's argument in Federalist 10 not only does not support exemptions, constitutional exemptions from burdensome laws, religious exemptions, at least I'm going to try to show, undermine his political science of liberty. Okay, let me see if I can persuade you of this. Okay, there are famous quotes from Federalist 10. It's somewhat elementary to present this slide at Princeton, but nonetheless. As you'll remember, in Federalist 10, Madison offers a Republican remedy for the diseases most incident to Republican government. The problem, of course, is the violence of faction. It's important to clarify that factions, by definition, are bad, because factions are averse to the rights of others or to the common good. I want to emphasize, especially to the students who might be taking Introduction to American Government right now, Madison does not call for a multiplicity of factions. Commentators frequently make this mistake. It didn't take me long to find a famous Princeton graduate who made this mistake. So this is a photo of my actual copy of the Conservative Sensibility. You'll see my notes in the margins. This is George Will's take on Federalist 10. And he says, Madison cultivates factions. That's not his solution. Madison's solution is not that if everyone is factious, then somehow everyone's bad behavior will check one another and a good result will emerge. Madison doesn't offer an invisible hand argument like Adam Smith. And understanding this point is absolutely essential if we're to understand Madison's argument. So I want to explain this point. Okay, Federalist 10 offers a two-part solution to solve the problem of majority faction, right? Representation in the multiplicity of interests. Madison famously proclaims that given human partiality and self-interest, the latent causes of factions are sown in the nature of man. We have different opinions, we're fallible, we have different interests, different faculties, we're prideful, we're passionate, we're self-interested. it's human nature to fall into different parties. And in an expansive republic, a large territory with a large population, a greater variety of parties and interests will emerge. Madison reasons it will make these greater multiplicity of interests will make it less likely that a majority interest will exist, or if there is a majority interest, that majority will be unaware of its common interest. So it's the fragmentation of a large society makes it less likely, or more, makes it more likely that every interest group will perceive itself to be a numerical minority. Okay, that's part one. I mean, this is, you all learned this in Government 101. Because the Constitution establishes a democratic republic, groups have to form majority coalitions to govern. The multiplicity of interests made possible by the large republic is meant to discourage the formation of majority coalitions adverse to the rights of others, and to encourage moderate coalitions that advanced just interests consistent with the public good. Federalist 10's argument does not presuppose that self-interest and justice are necessarily opposed. Some interests are compatible with the public good. So we don't have to overcome self-interest. Rather, Madison wants to show how factions can be neutralized and overcome so the public good can be pursued. Okay, if that was too abstract, let me try to explain in a simple example. We have a small republic and a large republic, right? A small republic has 5 members, the A's and B's. The A's have 3 members, the B's have 2. The A's are going to dominate, right? There's nothing, the A's will always have a numerical majority. Okay, my simple larger republic, now we have A's through I. So there's more A's, there's 6, there's still the largest group, and there's 3 B's and 2 C's, and it's 19, so you need 10 to have a majority. Well, now the A's have to make a coalition, right? And even in the A's and B's, the 2 largest group, have to bring in one of the smaller groups. Okay? Let's add an ideological spectrum, right? Let's say that the A's are on the left and the I's are on the right. Let me advance the slides here. Let's say we have a policy 1 that the A's favor. The A's are very much in favor of this policy, right? So starting on the left, policy 1. The I's are the most opposed, right? And the C's and D's are opposed, but less so than the I's. Okay? Policy 1 can't get enacted in our large republic. There's just not a majority of 10 to get to it. Okay, so let's say there's a policy 2, right? It's a more moderate policy that the B's, C's, and D's favor, but it's moderated in such that the A's don't favor it. But neither do the E's through I's. Policy 2 can't get enacted either. Again, this is just a simple model to illustrate what Madison is trying to do. In order to enact policy 1, the A's need 4 votes. They have B's support, so they only need 1 additional vote. So we might expect the A's to moderate policy 1 sufficiently to attract the C's. So we have a moderated policy, policy 2, but to get the C's, it goes too far away from what the A's want. So group A will not support policy 2. So policy 1 or policy 2 can get enacted. Okay, so the more bargaining takes place, and the B's, C's, D's, E's, and F come up with policy 3. This is a more moderate policy, right? This is what Madison's multiplicity of interests is designed to foster, a centrist majority coalition. The schema is intended to frustrate legislation such as policy 1 and even policy 2 and favor legislation like policy 3. There's no guarantee, of course, that the centrist position is necessarily what is most conducive to the common good. To some degree, the moderate position or the centrist position functions as an approximation of the public good in this aspect of Madison's argument. But Federalist 10 offers an argument that suggests the process of coalition building among a number of non-majority interests will likely bend towards the common good. That is, the central position will tend to be the common good. And this is a point I think scholars have missed. Right? In discussing the advantages of the multiplicity of interests and the necessary the necessity of forming majority coalitions, Madison remarks, where there is consciousness of unjust or dishonorable purposes, communication is always checked by distrust in proportion to the number whose concurrence is necessary. Madison's point here is relatively simple. The larger the number of disparate groups, each of which is protective of its own interests and distrustful of others, the harder it will be to form interests around unjust or dishonorable purposes. The argument presumes that groups can more easily and more openly advocate for just and honorable causes than unjust or partial ones. For the faculty here, think about faculty politics and negotiating for faculty positions. Madison's argument presumes that at least some shared sense of political justice exists and that various groups in society will be attracted to it, and therefore that majority coalitions are more likely than not to be formed by appealing to and proposing policies that appear to be consonant with the community's sense of justice. So Federalist 10 does not necessarily transcend self-interest, to repeat a point already made. It does presume that individuals and groups are attracted and attached to justice, or at least seek to avoid the appearance of acting in an unjust manner, and therefore that it will be more difficult to build a coalition to pursue dishonorable and unjust policies than it will be to form policies that are perceived to be unjust. Okay. Madison returns to this argument in Federalist 51, and I think some people haven't noticed. I mean, most scholars don't write about these things, but there's a real connection between Federalist 51, which is on the separation of powers, and Federalist 10. And this is what Madison says in Federalist 51, hearkening back to his argument in Federalist 10. In the extended Republic of the United States, and among the great variety of interests, parties, and sects which it embraces, a coalition of the majority of the whole society could seldom take place on any other principle than those of justice and the general good. So it's not a multiplicity of self-interested factions. The multiplicity of interests makes possible a coalition of the moderate and just. This probably seems very elementary, but scholars just haven't noticed this argument for justice in Federalist 10. Okay. I've said nothing about exemptions yet. Let me apply this back to exemptions. Okay, see if I can do this here. Remember, Policy 1 or Policy 2 could not gather enough support to be legislated. Only Policy 3 could be legislated by forming a majority coalition of the center. I made an assumption here, an important one, that the policy would apply to all groups equally. What happens if we remove this assumption and introduce the possibility of exemptions? How will exemptions affect this group bargaining process? To recall, Group 1 prefers Policy 1, and they prefer that it applies to everyone. But short of that, they want a Policy 1 with as few exemptions as possible. To recall, Group A was unable to secure the single additional vote to pass Policy 1. Exemptions offer a possibility to Group A. Right, it's obvious, right? Rather than moderating its position, right, to move to the center, Group A can offer an exemption to one of the groups that oppose it, right? G, H, or I. Consider the interests of groups G, H, and I. In our non-exemption example, they were able to join a majority coalition to prevent Policy 1, which they disagreed with, and Policy 2. Only when the centrist Policy 3 was proposed did Group F join the majority coalition. Groups G, H, and I were opposed to Policy 3, but given their positions on our ideological spectrum, we can presume Policy 3 was less noxious than Policy 1 or Policy 2. The possibility of exemptions changes the calculus for groups G, H, and I. If we can presume that they anticipate that a centrist coalition might form to pass Policy 3, and again, they're against Policy 3, these groups now have to weigh the balance. Do we prefer to be subject to Policy 3, which can pass with the majority, or do we go for an exemption and vote for Policy 1? Everyone follow the dynamics here? So, sorry. Group I has three possible outcomes. They can be subject to policy 3, which they disagree with. They can be exempt from policy 1. That is, they can vote for a policy that they abhor and be exempt from it. Or they can be subject to policy 1 because some other group gets an exemption. Everyone follow here? So what's the rational thing for group I to do? It's to bargain for an exemption, right? To support a policy they disagree with, right? So they don't have to be exempt to it. Especially if they know if we don't get the exemption, who will get the exemption? G or H. We would need to add a dimension of intensity of group interest and construct a more complicated model to predict whether our large republic would more likely adopt policy 1 or policy 3 or policy 1I with an exemption for the I's. But the point of this simple example is not to predict what would likely happen, but to illustrate the availability of how exemptions can alter the process of majority coalition building. There's now two ways to build a majority coalition. The Madisonian policy, the moderation the Madisonian wanted, policy 3, or a coalition of the extremes, policy 1 with an exemption. Federalist 10 anticipates that a multiplicity of interests will encourage the formation of centrist majority coalitions. It does not anticipate the ideological opposites might join together, as happens when exemptions are possible. Indeed, Madison's argument presumes that the disparate interests of an extended republic will help prevent such partial coalitions and partial legislation from being adopted. With exemptions, we see majority coalitions can be formed without a shared understanding of the public good. Group I voted for policy 1 despite hating it. In this way, exemptions undermine Madison's reasoning of how the multiplicity of interests will favor the moderation and centrist coalition he associates with the public good. Okay, I could take another 15 minutes and go through representation and explain the same thing. Representation and multiplicity of interests are the two-part solution of Federalist 10. The same thing happens with representation. I can illustrate it very simply. Imagine you're the representative for Group I, right? When there's no exemptions, you're representing your group's interests. You just are objecting to everything, or at least trying to encourage the center group to be as moderate as possible. When exemptions are possible, if your interests are simply to look out for your own group, right? In a way, you're no longer concerned with the common good. You're concerned with just getting an exemption for your own group. It changes the dynamic of representatives are supposed to refine and enlarge the public view. Exemptions let representatives narrow and be more self-focused for their own group's interests. Okay. Let me turn to Federalist 57. There's a quote here that's especially important. In Federalist 57, Madison returns to the topic of representation, and this time in the context of analyzing the House of Representatives. Madison writes that among the circumstances that will restrain members of the House from passing oppressive measures, and you have the quotation here. So the context of this discussion is, how do we know when we elect members of the House that they'll be faithful representatives, they'll actually represent the common good? They'll refine and enlarge the public views. And Madison says the surest way is that those representatives will have to pass, the laws they pass will apply to themselves and their friends. That is, Group I can never favor legislation that doesn't apply to itself. And exemptions undermine what Madison says is the surest argument that representatives will be faithful. Okay, if I haven't made it obvious, what I'm trying to show is exemptions undermine Madison's political science of how representation in the multiplicity of interests, when coupled with the uniform application of law, prevent factious legislation. Okay. My argument is Madison's political science can help us understand the First Amendment. If we take the argument of Federalist 10 as indicative of Madison's thought as a whole, it seems implausible, if not impossible, that the father of the Constitution conceived the right of religious liberty to consist in exemptions from otherwise valid laws. Indeed, I think it, on balance, clear that Madison's political science supports an anti-exemption construction of the Free Exercise Clause, the exemption that I suggested 2 years ago here, and I suggest in my book, and the one that Justice Alito rejects. The political science of Federalist 10 complements Madison's more philosophical writing about natural rights, especially the Memorial and Remonstrance. Madison's constitutionalism can be conceptualized what I call a two-track theory of religious liberty. Political arrangements designed to prevent oppressive legislation, that's what we just talked about, supplemented by principled constitutional limits that prevent a specific type of law, laws that directly target religious exercises. In my forthcoming work, I'm going to label this approach republicanism and rights. We've forgotten the republicanism part. The republicanism tract operates within the framework of majoritarian politics, where again, Madison contends that representation in the multiplicity of interests will make majorities govern better. That is, they'll make factious legislation less possible. The rights tract is secondary. Madison's republicanism tract is far farther reaching than his rights tract. It's really representation in a well-constructed republic, that is, with a multiplicity of interest, with requirements such as the equal application of law. Those are the institutional designs that will protect us against legislation that is adverse to the rights of other citizens or to the permanent and aggregate interests of the community. So it's actually Madison's majoritarian political science, only supplemented by his legal and constitutional principles of religious liberty. That is, it's a Republican solution, not a judicial solution that will protect religious liberty. The political science was designed to play the primary role. We've forgotten this because lawyers and not political science dominate our understanding of the Constitution. I'm especially pleased to present this lecture at Princeton because the political science of Madison is nowhere better understood and I think appreciated than here. Thank you very much.
Thank you very much, Philip. Our custom, as you'll recall from the Madison program, is to open with questions from students. And I see in the audience some of my very best students who have, against my will, extracted very good grades from me in my courses. So would any of those students like to begin with a question? You have no takers? They're usually not this shy, Philip. If we don't have any, oh yeah, okay, here we go. Thomas, please, go right ahead. Thomas Hilliard.
So when you gave the examples of the A through I's, I see the appeal of that on issues that are close. But what about the lone I who stands alone in some belief that everybody else, won't support them on? How do we stand up for I in that situation? Because it seems like under this understanding, if there are no exemptions, they can just get run over.
Yeah, okay. So what do we do about the Amish? The Amish are not a majority, they might not be as far off as the I's, but there's not a lot of Amish. They're never going to be a dominant group in Wisconsin or any other state, right? So Madison's solution is for the Amish to persuade the rest of us that it's unjust to make them go to school. So let's think about how the Amish might do that. right? They can emphasize their peculiar character, right? Look, we Amish have these religious beliefs for these reasons. We think school will interfere. They could be especially Amish, Or they could make arguments such as this. There are other people who might not want to send their kids to school too. Other religious groups, other non-religious groups, right? Do we really have to make every kid go to school to get an education? Look, we the Amish actually educate our students very well in the trades. Are there not other groups who might also have alternative forms of education? And they would try to form a coalition of the majority. And instead of trying to get an exemption, Madison would say, you would try to change the law. Maybe expand the law. You have to send your kid to a public school, a private school, or offer some alternative form of schooling that prepares them to assume the responsibility of citizenship. That's how Republican government is supposed to work. It might not. The Amish might not get the exemption. And if they don't, they should bear witness and try to use civil disobedience and explain the justness of their cause. But see, Madison wants the Amish and other groups to make arguments from the common good and justice, not emphasize their peculiar character and their distinctness. It may not work. Republican government is not perfect. The more laws we have, the more burdens that minority groups, numerical minority groups might suffer.
Do you want to come back, Thomas? Do you want to ask Professor Muñoz what you do in a situation when a legislature has decided to grant the Hutterites an exemption, but not the Mennonites for an exemption, and whether that raises a constitutional issue? You want to ask him that?
Sounds like professors asked the question.
Thomas asked a question.
Thomas didn't want to answer that question. Well, if we were strict in applying Madison, you couldn't offer the first exemption in the first place. No one would get exempt. I mean,
That's
Madison.
not your position.
That's not my position. Yeah. I'm here to explain Madison's position.
Okay.
But Madison is the father of the Constitution. And it seems that, so I was trying to be within my allotted time. The exemptionist position, Justice Alito, and Michael McConnell. Michael McConnell is a Stanford law professor, a former judge. If John McCain had won the presidency in 2008, he would have been on the Supreme Court. I mean, he is, along with a few others, he's the dean of originalist law scholars. Michael McConnell relies on James Madison to defend an exemptionist approach. And Alito relies on McConnell. So there's a little bit more to context to my story. I'm trying to show it's implausible that Madison defended exemption. Now, let me say one other point here, though. In my work, what I try to do, in the book, I try to explain this is what a natural rights approach to the Constitution is. Right? The founders were partisans of natural rights. Let's try to understand them. Only after we understand them can we start having arguments on whether their constitutionalism is worthwhile to follow today. Right? It might not be. I mean, most originalists would say, I'm not an originalist. They don't like my style of originalism. My argument is, let's try to understand these theories, let's play them out, and then let's have an argument whether a natural rights approach is a worthwhile approach. Maybe Madison's constitutionalism, it doesn't work today. Maybe it was never just. Right? But we can't have those arguments until we understand the approach.
So just to bring everybody onto the same place, Professor Whittington's students and my students will remember that it was Justice Scalia in the case of Oregon against Smith, which did away with, for all intents and purposes, the prior jurisprudence of Yoder against Wisconsin, although it left Yoder in place in a technical sense, kind of put it in formaldehyde. But it was the Smith decision that overturned the requirement that a general neutral law, if it impinged on religious free exercise, would need to be defended as having a compelling state interest and representing the least intrusive or invasive means of prosecuting that interest. But Scalia's position was that while courts cannot grant exemptions to such laws, legislatures may. Right?
Yeah, that's right.
Yeah.
Yeah. So Madison goes even further. I mean,
That-
his political science is no exemptions at all.
Yep. Next question. Thomas.
Hi there, I'm James.
James Jordan.
I have a question about sort of the answer that you just gave. It seems in the Amish case where they're trying to convince people, they're trying to change the law. And let's say they get the law changed to you have to send your kids not through 12th grade, but you can have this other option. And they formulate it at sort of this level of generality so that it's not an exemption. It seems to me like that's just a semantic issue at that point. It's an exemption is an exemption when it's targeted, and it's not an exemption when we formulate it in this vague way such that it becomes a law of general applicability. So how is this not just a semantic issue if people are just allowed to bargain for their position in this political process?
I'm not sure I'm quite following, but whatever, the same law would apply to everyone, right? So everyone can have three options: public school, private school, or homeschooling. The exemption is only when, so the result of Wisconsin v. Yoder was the Amish parents didn't have to send their kids to school, but everyone else still did. So there wasn't the equal application of law to everyone. Does that answer your question?
No, I guess my question is, if they add a clause to that law saying you have this third option, but everybody knows that third option, nobody else is really going to avail themselves of it. It's just for the Amish. But it's formulated in such a way that it doesn't use the word Amish or it doesn't refer to them specifically.
It's
but
Curious Joel. He's asking you about the
yeah.
Curious Joel case.
Well, you could still have pretextual analysis and things like that. But how do you know no one else will avail themselves of the option? I mean, does no one else have the same interests as the Amish? I mean, it could be in certain circumstances that is the case, and maybe there's nothing wrong with that. But it turns out, actually, when you're making the same law apply to everyone, there is actually this moderating influence. And you will find, look, there was no homeschooling movement, right, 50 years ago. And you have to, I mean, I'm no expert on this. I would guess there was no homeschooling movement because there were mandatory school attendance laws. Jeff Vaughn is shaking his head. Is that not correct? Or, yeah.
I have a question if I...
Yeah, go ahead. Yeah, go ahead.
Well, on the homeschooling, it's actually, I think in Connecticut, the original Connecticut Constitution, everybody has to be educated even if that means going to school. So it had a presumption for homeschooling, so just historically.
Even if you...
Yeah,
yeah,
even if...
that's
Yeah.
funny. Yeah.
So I think it's great that you came up with this, especially that earlier, the A's through I's.
Yeah.
But really at your knee surgeon, it looked like it was from an optometrist's office. We go way back, so I can tease him on this. But my question is, so what you're looking at is a legislative issue, right? Not a legal issue. And I'm wondering if it's because when you're drawing on the Federalist Papers, and you're referring to Madison as the father of the Constitution, he kind of had a second child in the Bill of Rights,
Yeah.
right? And we know that he initially didn't want a Bill of Rights. But it's the Bill of Rights and it's that First Amendment that is sort of causing this problem of exemptions. And wouldn't it make more sense, wouldn't a better reading simply be you cannot have any, so the proper decision in Yoder would be overturn the law entirely. Just change the law just has to go completely, right?
Well, so two things
So,
here.
yeah.
There's two questions in your question. One is, there's a presumption that the free exercise clause does provide exemptions, and therefore it's a problem. But that's exactly what I'm denying. Let me back up and give a little bit more context here. Judge McConnell, Justice Alito, everyone but Robbie says, the free exercise clause has to mean exemptions, because if it doesn't mean exemptions, it doesn't mean anything, right? And what I'm trying to show is, no, it actually does do some work. It makes clear that you can't, that is, the government can't target religious exercises as such. Right? That's a principle that comes straight from the heart of liberalism, or natural rights liberalism. Right? But the First Amendment had a relatively narrow, the work it does is relatively narrow. Right? It turns out the founders, I mean, this is part of my larger argument, the founders were much more Republican or democratic. Not Republican in the Ronald Reagan sense. Republican government. Right? They're much more Republican than we presume, and much less libertarian than we presume. Again, we might not like that. We might think that's not sufficient. That doesn't work today. Right? That's an open question for me. But I'm just trying to show their constitutionalism. Okay, let me say one other point here, and I put this slide up for a reason. Right? Down here when I'm talking about Madison's, so the next project I'm going to do is it's on America's two constitutions, or two constitutional traditions: a natural rights constitution, and what I'll probably call progressive autonomy constitutionalism, or just autonomy constitutionalism. Wilsonian, and here I contrast the Madisonian approach, which I say is jurisdictional, with a managerial. What do I mean by that? A jurisdictional constitution. Think of the role of the Supreme Court. The role of the Supreme Court in Madison's perspective is to say, Congress, you can do these things, and you can't do these things. And so the court would answer most questions yes or no. Yes, you have the power. No, you don't. No strict scrutiny, no least restrictive means, intermediate scrutiny, no tiers of scrutiny at all. I presented this to a bunch of lawyers on the Sixth Circuit in September, and they thought I was crazy. What do you mean, no strict scrutiny? That's what we do. And then I said back to them, that was only invented really in the 60s. And they're like, well, that was, before that was prehistoric times. But there was a constitutional tradition before strict scrutiny. Managerial is, what I mean by that, it's the courts are managing the right result. Yeah, we want to make kids go to school, but not the Amish. And so they're managing an effects society. Now, maybe that's good. We're at Princeton. Where do the Supreme Court justices come from? They come from places like Princeton. Maybe we think that's a good approach or a necessary supplement. Right? Okay, we have democracy, but then we have a managerial Supreme Court. That's a different model of constitutionalism. I'm trying to bring out the differences so we can have a more intelligent discussion of the merits and demerits of both. There's way in the back there.
Oh, yeah. Yep. I have a student, I think, here. Yep.
Hi, my name is Noelle. I had a question about your policy bargaining sort of diagram. My question is, how likely is it really that the I's on the far right are really going to vote for the A's over here, even if they do offer them an exemption? Especially since I'm just thinking maybe the moderates in the middle, once they see that A have offered the I's an exemption, will also jump on that and offer them an exemption as well. And then, the I's are much more likely to vote for the moderates instead of their enemies over here. And so then the idea of the multiplicity of interest still tending towards, just moderate policies still stands.
Yeah, no, I love that question. So the question, if you couldn't hear, is, are the I's really going to get the exemption, or, who's going to get the exemption? I am trying to find a game theoretician who will model all this out for me. This is about as political science-y as I can be. Right? But I think these are really interesting questions. I'm not trying to make a model that will predict behavior, though. I'm just using the model to illustrate possibilities. I'm interested in your question as well, and it would be really interesting to know if you could build a model, and you'd have all sorts of assumptions, and predict who will get the exemption. Now, the reason the I's are most likely to get the exemption is because if you remember, they're the furthest over on the right. They like the law the least. That is, they'll take the most minimal exemption. Right? The A's, the payoff the A's have to make is smallest. So it, in a simple sense, makes sense. Now, whether to what extent actual politics would follow the model, I mean, you have models to construct models. Models aren't perfect, right? So there's all sorts of interesting case studies. I'm trying to find a student to take some major exemption pieces of legislation, prohibition and things like that. Catholics got an exemption. Would the amendment banning alcohol ever have passed if there wasn't an exemption for Catholics? So this is a question I always get. I'm Catholic.
Now, just to be clear,
Yeah.
Catholics didn't have a general exemption from prohibition.
Yeah.
The only person who had that was Winston Churchill when he was in this country.
Yeah.
They had an exemption, so did Jews, for the liturgical use of wine. So at a Passover Seder, at a Catholic mass. So it was they were very narrow.
Yeah, so people always ask, my Catholic friends always ask me, so you would have, not given the Catholics an exemption from prohibition, as this is some moral taint on me. And my response is always, no, we never would have got prohibition if an exemption wasn't available.
That would be interesting to
So that
to
would
debate.
be, but someone, I just say it, and they don't know what to say in response, and then I just walk away. But it would be interesting, actually, to go into the history of all these laws and do exemptions facilitate what the model suggests.
There would have to be times, Philip. There would have to be
well,
times.
yeah,
Professor Patton.
Yeah, this sort of leads to a question I was going to ask.
Microphone so we can get it on the video. Thank you, Christy.
Thanks, I really enjoyed the lecture. The defenders of exemptions often emphasize the possibility that Democratic majorities would be ignorant of the religious needs of religious minorities, or perhaps neglectful or hostile, or also sometimes the possibility that they will kind of verbally gerrymander
sure.
laws so that they don't explicitly target particular groups, but in effect, everybody knows the reason why the law was sort of worded in this way is so that it picks out that particular group. It felt like those kinds of factors are not really picked up by the political science model from Madison that you're emphasizing. And the last case of your confidence that Catholics wouldn't have supported prohibition if not for a legislative exemption. I mean, that's sort of venturing onto that terrain because you're kind of making predictions about some of those things, neglect and hostility and so forth. Interesting case to think about would be the Oregon case that Professor George mentioned, where it's plausible, I think, that the lawmakers who made the drug laws in Oregon maybe weren't even thinking about the Native Americans and their use of peyote, or if they did, they had perhaps contemptuous attitudes about it. So how do you fit those kinds of considerations, which don't seem to figure in Madison's model, into your overall argument?
Yeah, no, this is great. I mean, if I knew Professor Patton was going to be here, I would have had another category here. I mean, Professor Patton writes on these things as well. You call this approach no burdens, I think, and then there's non-discrimination. This is not the same as non-discrimination. And then Professor, it's been a while since, fairness, I can't remember your, how would you?
I have a fair opportunity.
A fair opportunity model. So these are not the only two possibilities, right? There are other possibilities, and Professor Patton would be right in here, I think, if I remember the article correctly, right? And so what he's asking is, well, this approach over here turns and this is to echo the question over here, turns everything over to Democratic majorities. And there's all sorts of things that Democratic majorities, just in ordinary democratic politics, will not take into account of. In Oregon, there's a law, just to fill in the details of the case, the state of Oregon had a prohibition against hallucinogenic drugs, which included peyote. Might seem improbable that Oregon would have such a law, but they did have such a law. And there's a group, the Native American Church, clearly a religion and a very old religion, and they've been ingesting peyote, I think, for generations. It's probably true that the legislature of Oregon had no idea that they were effectively making this
But to be
religious
clear, they
group.
were ingesting the peyote in the sacramental context, regulated by the tribe, and actually forbidding the use, the tribe itself forbidding the use of that or any other drug by members of the tribe outside of the sacramental context.
Yeah, peyote is usually not a drug of choice. You know, it has, I'm told, all sorts of unpleasant things. So this is, you know, there wasn't an epidemic of peyote users, right? So Professor Patton's point is, well, what about all, especially small groups that the legislature won't be aware of, or maybe they will be aware of and be indifferent or hostile to? Doesn't that bring up all sorts of concerns regarding recognition and respect? And my answer is yes, it does. And republicanism might be inadequate, right? But this is the founders' constitutionalism. We'd have to examine its strengths, also its weaknesses, as compared to this alternative, which has all sorts of strengths and all sorts of weaknesses, and try to reason it out. My work is really, it's normative political theory, but I'm just trying to articulate the alternatives so we can have a much more intelligent conversation about what those alternatives are.
Now, if Justice Scalia were here, he would be pointing out with some glee that after the Native American Church lost its case in the opinion that he wrote, essentially for all intents and purposes overturning the previous jurisprudence, the Oregon legislature, having won and made its point, turned around and legislatively granted an exemption for the sacramental use of peyote to the Native American Church. So Scalia would say, republicanism works, and would use that as an example.
I mean, and so it'd take a lot more work than I've done. I mean, just to repeat something, the founders were much more Republican than we imagine, right? I think this is, you know, whether that's insight is helpful or useful or good to know, maybe it's just a, you know, historical interest to a few of us. Let me add one more point here, Robbie. There's this common good constitutionalism that's been emerging. Mm-hmm. Your friend Adrian Vermeule. They don't actually. They're sort of. They can't figure out if they like the founders or dislike the founders. They seem to say both. You know. It turns out the founders are much more open to common good arguments, I think, than they realize. Right.
Well, I mean, that's not just one. I mean, there are different people who have different perspectives within that general school of thought. And I think that might be one of the things on which people within that school of thought disagree, you know, about whether the founders actually were common good constitutionalists themselves to some extent, or opponents of it.
Yeah, but there's the founders' republicanism is much more open to the state doing things that some citizens might not like in the name of the common good. We might not like it, right, because of the peyote users and the eyes, and geez, we might think it's, again, my role as a scholar is to articulate these alternatives more clearly than I think has been done before. And so I'm really trying to be modest in what I'm trying to argue for.
Alexis?
Hi, I'm a postdoc at the James
Louder,
Madison
please.
program. My question was about some of the presuppositions about these kind of discussions. So I understand that in the US, churches, for example, are exempt from taxes, or at least to some extent. Doesn't that presuppose that there is an essential difference between churches and other forms of civil associations? And doesn't that conflict with your view that there shouldn't be exemptions under the Madisonian conception of the constitutional rights?
Okay, so for the church-going folks here in the room, when's the last time you've heard a sermon against excessive taxation? And why haven't you heard such a sermon? let's imagine that churches, just for a moment, were not exempt from property taxes. What consequence would that have? Or let's throw in universities while we're at it.
I was just about to do that.
Yeah. I mean, the fact that
Let's narrow it down. Sociology departments.
I mean, the fact that I pay more property taxes than the University of Notre Dame does irritate me, right? It would be interesting if churches had to pay property taxes. And you should really think it through. Would that lead to better government or worse government? I think it's a fair question. Now, if we are going to give churches property taxes, how ought we to do that? Would it be better or worse for the IRS to say, yes, you are a church and you're not a church, or for churches to fall into some other group, nonprofit or something like that? Right. So your point is well taken. I think Madison's response would be, well, actually think about taxation and exemption. Does exemption lead to a better and fairer taxation in the long run? I think that's an open question, actually. I mean, those are the types of questions I'm trying to get us to think through.
Do you have a question over here? Yeah.
Thanks. I'm Ben. I'm a sophomore. I really enjoyed the talk. So I have 2 short questions and then a longer question. So just to try
Spoken
to be
like a professor, yeah.
So my first short question is kind of, when you were talking about the balancing test, strict scrutiny, things like that, I know a lot of people have been writing about, especially in the wake of the Bruin case, about a return to a kind of text history tradition kind of standard rather than these essentially constructed balancing tests. And that's like, to put it very briefly, is sort of what you're arguing for the First Amendment. Like if you were to summarize it really, really briefly, it is that kind of, again,
Affirmed.
Okay. So then second question is are legislatures then able to target, like you have up there, government cannot target religious exercises under your view. But like you mentioned the Aztecs earlier, if they're saying that child sacrifice is their religious exercise, they're not allowed to sacrifice children outside of that. In fact, they prohibit it. But during their sacramental process, organized by the Aztec tribe, they can sacrifice children. What can the government do about that?
Yeah, under my approach, if you can prohibit murder, then the Aztecs would have no right.
Yeah, that's an easy one for
That's
Professor
an easy one.
Muñoz.
So, but go ahead.
That question
Yeah.
is the one you'd ordinarily direct to Professor McConnell or Justice Alito. Yeah.
Let me say one other point, though, here, that this is more on the book I just published than the talk today, but in the Founders' understanding, natural rights have natural limits. Right? We don't understand this today. The natural rights are bounded. Hamilton once said natural rights are bounded by the natural law. Hadley Arkes likes to say there's no right to do wrong, and confuses people. And, but what he means is your natural right to religious liberty, or let me use free speech. Almost everyone recognizes your right to free speech doesn't mean you can say anything. You can't libel people saying false things, knowingly saying false things about them. Well, that's speech. But the right to free speech is bounded, right, by the natural law. It's wrong to lie about people. We all understand that. Same with religious liberty, the natural right to religious liberty. It's bounded by the natural law. Sacrificing children or murdering children is against the natural law. There's no natural right. I'm giving you a long answer to your simple question. When I say free exercise has an objective meaning, and Alito says it has a subjective, by that I mean Alito would define, what is free exercise? Alito would define it by, the subject defines free exercise. That is religiously motivated behavior. If you think it's if you're doing this for religious reasons, it falls within the free exercise clause. So the subject defines the scope of free exercise. Right? Everyone follow that? The Founders' understanding was, no, free exercise was an objective thing. There's something called, the simple case, worship. And that's outside the jurisdiction of the state. Right? So there are certain things the state can't do. The state can issue law licenses, medical licenses, cosmetology licenses, but not preaching licenses. The state can't issue preaching licenses because it's outside of its jurisdiction. It's just a very different approach to constitutionalism.
Third question.
Yeah, that one took a little bit of a longer answer. But anyway, yes, so the third question, kind of to get at the broader concept you're getting at of obviously at this time, the Bill of Rights, at the founding, it only applies to the federal government. This is long before incorporation doctrine. And something I take from the thought of Father Richard John Newhouse, particularly about the American proposition, the idea that you have this democratic system, so there's not permanent winners, there's this constant debate, this constant back and forth. Our eschatological concerns are something that he would say is prefigured in the Mass, something like that, in the life of the church, not something, we're not doing eschatology in politics. And saying that because of that, there are these broad spheres of liberty that should be protected, especially at the national level. And kind of, I think, my challenge, I guess, or issue with your view is that these minorities will be well and actively represented in national politics, which many religious groups simply are not. Many minorities are not. And I think it's often better that they don't have to be obsessed with national politics, that they are in constant fear that their way of life could be destroyed by not having enough influence in the Senate or the House of Representatives, that, more akin to what Newhouse is saying, kind of allow this space for these communities to flourish, and then for regulation, but particularly pre-incorporation at the state level, at the local level, but the federal government should give kind of a broad, take a broad step back for these things that are so fundamental and important. So how would you respond to that?
Yeah, no, that's very good. I think, well, in general, favorably, right? I think federalism, so the difficulty we have is federalism for many people, reasonably, is just associated with states' rights, which is associated with segregation, right? Federalism in practice was used to terrible effects in America, right? And for many people, that just discredited the idea of federalism, right? I see this in my colleague Sat Barber, right? Sat hates federalism, and he hates it because he associates federalism with, federalism means segregation, legal right to segregate, Jim Crow. One can understand that, right? This country pays for the original sin of slavery over and over and over, and the loss of federalism is one of the payments. But it doesn't mean federalism as an idea is totally discredited. Right? It was used for bad purposes. And so I actually think reinvigorating federalism to be used in just ways with just limits would be healthy. So I don't disagree with that. The only direct application here, connected really to federalism, to my talk, is the states at the time of the founding also said religious liberty was a natural and inalienable right. So there were state limits, there were state jurisdictional limits as well. So this particular issue, the lack of jurisdiction of government over religious exercises, was not, it was limited against the federal governments, but also at the state level.
Some of you who regularly attend Madison program events might remember Dean Heather Gerken of Yale Law School gave one of these lectures a year or two before COVID, in which she made the argument it's time for progressives like herself to reclaim the doctrine of federalism and to get away from the idea that federalism is permanently stained because it's tied to slavery and segregation. Professor Cameron.
So suppose you persuaded Justice Alito and 4 more justices on the court. I'm wondering, when I open my newspaper in the morning, what are going to be the big cases that I would be reading about if they pursued this aggressively? In other words, how does this cash out?
Yeah, very good. Well, having hosted Justice Alito last year at Notre Dame, I can assure you I have not persuaded him. Yeah. It was very funny. We had a very awkward moment because this was in September, like 2 months after the Fulton decision, and he came to Notre Dame, and I was hosting him for lunch, and we were walking, and we're just standing there, and I think he's kind of a shy man because he didn't say anything, and it was kind of like, okay, who's going to bring it up first? Anyways, it didn't get less awkward after that. Here's the context. The New York Times headline, if the conservative justices accepted my position, would be conservative justices find the Constitution offers religious citizens no protections against non-discrimination laws. The Masterpiece Cake Shop, the guy has to make the cake for the gay couple. And that would be front page of the New York Times. It's Justice Sotomayor, another Princeton graduate, who's more interested in this, using this, than Justice Alito.
Well, since Professor Cameron has opened up the question of the contemporary political significance of it, maybe you could offer a few comments on that more broadly. Some of you are old enough, as I am, to remember when Smith was handed down, and it did something that no other case in my lifetime had ever done or has done since, and that is it united the right and the left. The right and the left hated the decision. They condemned the decision. They condemned Scalia. Richard John Newhouse on the right said that Scalia had written the Free Exercise Clause out of the Constitution. The ACLU condemned the decision. People for the American Way condemned the decision. The Moral Majority condemned the decision. The Christian Coalition condemned. It was national unity for once. It was
It was a coalition of the A's through the I's. Yeah.
And I remember this very well since, as Philip noted, I was one of the few people who said Scalia was right. And you got a lot of grief, you got a lot of grief for that. Well, the country was united around Yoder, basically. And Yoder, if you think about it, the Wisconsin Amish case, even though it occurred after Justice Warren had died and been replaced by Justice Burger, was essentially a Warren Court decision. And the justices there were, all the old Warren justices joined. There was a concurrence with just a little note of concern by William O. Douglas about, maybe parents having too much authority to limit the horizons of their children. But it was basically a Warren Court decision. Look at how the politics has changed today. Today it's a right-left issue, right? Now, how did that happen, Philip, and what's its significance?
Well, I mean, that's a involved question, right? I mean, you've had the embrace of gay rights and other expansions of civil rights, right? And that take the Masterpiece Cake Shop. Everyone know Masterpiece Cake Shop?
Everybody will. It's the Denver case.
So right, it's in Colorado, and there's an anti-discrimination law, and that anti-discrimination law protects against discrimination of same-sex couples. And this guy owns a cake shop, and the students won't quite understand this. You have no idea, you students, how much a wedding cake costs. Whatever you think it costs, add 2 zeros to it. And this guy makes really high-end cakes. And this gay couple goes in and they ask him to design him a cake, and he says no. And he says no because I don't believe in gay marriage. If he had said no, I'm busy, I'm going on vacation, I can't take any more. It wasn't that he didn't make them a cake. He could have not designed them a cake for all sorts of reasons that would have been acceptable. What was unacceptable was he said, I won't design you a cake because you're a same-sex couple and I don't believe in that. He's an evangelical.
Yeah,
right?
He didn't design cakes
Right.
for Halloween.
Yeah.
He refused to design cakes for divorces.
That coalition that Professor George had in mind, it was a coalition to support the Amish, not the cake designer who would discriminate against same-sex couples. So just the politics are different, right? To get back to Professor Cameron, we haven't met before, To get back to if the court adopted this approach, no exemptions. In fact, if the court adopted this Madisonian approach, it would be even further. It would be no constitutional exemptions and no legislative exemptions, right? No RFRA. So this is, as Professor George was suggesting, this approach is far more extreme than even this is really, I'm pushing Madisonian as far as he goes. And Madison really stakes a lot on the equal application of law. So this quote from Federalist 57, I don't know if I can find it real quickly. Madison really thinks applying the same law, property taxes or non-discrimination law or whatever, that really what's going to make law better is you have to apply the same law to everyone. When I say I'm just trying to illustrate a position, I mean it. But someone's got to think through these things. And and it's not just I'm taking some obscure theory, it's James Madison, the father of the Constitution. And he's so far away from our constitutional practice today, right? I don't think we realize how far our modern constitutionalism has drifted from our founding era constitutionalism. Maybe it's just all improvement. I don't think it's all improvement, but I want us to think more intelligently about the differences.
Well, some news items would be things like Catholic Church is out of the adoption and foster care business. All of its agencies that have been in business for 120, 130 years have provided enormous amounts of service. It's second to the government. The Catholic Church is the largest provider of social services in the United States, and actually it's one of the largest in the world. It would have to go out of a lot of those things, and I think that would be the newspaper story: fire sale on foster agencies and adoption agencies. And the same would be true for the smaller religious communities that have similar moral views, the Lutherans, Orthodox Jewish, and so forth and so on. So that would be a very significant, newsworthy New York Times above the fold story.
Yeah.
One more question. Yes, Sean.
Hi, I'm glad you came back to Federalist 57, and I'd like to respond to the comment you just made. Zooming out from the issue of religious liberty, under Federalist 57, if we push Madison to his logical extreme, that would be something like flat taxes, no laws with differences between the sexes, because if you don't have a law that doesn't have its full operation on themselves and on their friends, how can you have any difference, right? If you have a gradated tax system, then you don't have that. So I'm wondering, how extreme are you willing to say that this Federalist 57 inspired reading is?
Yeah, no, I think you could have, you could have a progressive tax. You would be, whatever, your first $100,000, you pay 10%, your second 100, I mean, the same law has to apply to everyone. What you won't get is, like in my town, no developer will develop anything in South Bend without a tax abatement, right? And they're singular, right? We like you guys, you get you don't have to pay taxes for 8 years or 10 years. It's not even the rule of law. Taxation is almost individual, right? That's what Madison wants to get away from. So it's not, progressive taxation is no problem. But look at our tax code, right? It's certainly not the equal application of law. Every group gets the same treatment. That's what he wants to get away from.
Final point, since we have you, Philip, on originalism. So Judge McConnell, Professor McConnell, looks at the Scalia opinion in Smith. He's scandalized by it. He writes a very long article in which he documents exemption after exemption after exemption at the time of the American founding. And he said, look, if we're originalists, we have to understand that at the time of the American founding, the importance of exemptions was recognized. When the First Amendment was adopted, the importance of exemptions for minority religions, the Quakers, for example, when it came to military service and so forth, were respected. Scalia responds, wait a minute. Sure, there were all those exemptions, but that's not a problem from my view. Notice that all of those exemptions were legislatively granted. There's no originalist case for the judicial imposition against the will of the legislature of these exemptions. And so that's the argument about originalism there. You then come in completely orthogonally and say, well, wait a minute, both of them are wrong. That's just not a sound understanding of originalism. The originalism you're after doesn't ask the factual question, were there exemptions or were there not, who granted them? It asks, is the original constitutional architecture consistent with anybody granting exemptions? Have I got that right?
That's, yes.
Okay. I'm glad.
Someone else described it as dropping a bomb on everything. But this is, I'm just going to say one more time, what I try to do as a scholar is just follow the arguments out. That's my function. I mean, I'm not actually trying to get Justice Alito or anyone else. They do their job, and I do my job. And my job, as I understand it, is to take natural rights theory seriously, at least in this project, and try to understand it. I think that's what scholars are supposed to do, right? Happy to have, I can tell you why I think, if I were to critique Madison's position, I'd start with, well, the rule of law is not perfect for many of the reasons articulated here. But then we have to weigh the alternatives. Once we start recognizing certain groups because of their particular characteristics, what type of politics will that produce? And once we start trying to formalizing it in judicial decisions, those are the types of questions we have to really think through. That's what political scientists do. And again, I just don't think we've done a good job of thinking through the positions. Okay. Thank you very much.
Yes, thank you. Thank you, Philip.